Hello, everyone, and welcome. Thank you for joining us for our report launch, Challenges and Consequences, the Impact of Bill C-41 on Aid Delivery in Afghanistan. This report critically examines the effects of Canada's Bill C-41 on the delivery of aid in Afghanistan following the Taliban's takeover in August 2021. This report was made possible through the generous support of the Canadian Bar Association's Law for the Future Fund. My name is Zainab Jamal, and I will be your host and moderator today. Before we begin, I would like to remind everyone that this session is being recorded. So if you need to step away or visit any of the discussions, you will have access to it later. We will also run a live Q&A session at the end. So feel free to submit your questions using the chat or the Q&A box at any time during the event. As is our tradition with CCMW events, I would like to start our program with Surah Fatiha. أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين الرحمن الرحيم مالك يوم الدين إياك نعبد وإياك نستعين اهدنا الصراط المستقيم صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين آمين. In the name of Allah, the most compassionate, the most merciful. All praises for Allah, Lord of the worlds, the most compassionate, the most merciful. Master of the day of judgment, you alone we worship, in you alone we ask for help. Guide us along the straight path, the path of those you have blessed, not those you are displeased with, or those who are astray. I would also like to take a moment to acknowledge the land that we're on today. This land is the territory of the Huron-Wendat and Piton First Nations, the Seneca, and most recently, the Mississaugas of the Credit River. This territory was the subject of the Dish with One Spoon Wampum Belt Covenant, an agreement between the Iroquois Confederacy and Confederacy of the Ojibwe and allied nations to peaceably share and care for the resources around the Great Lakes. Today, the meeting place of Toronto is still the home to many Indigenous people from across Turtle Island, and we are grateful to have the opportunity to work in the community on this territory. I would also like to pay my respects to their elders, past and present, and to any who may be here with us today, physically, mentally, emotionally, and spiritually. Miigwech. I now would like to pass it off to Nuzhat Jaffrey. Nuzhat is the Executive Director of the Canadian Council of Muslim Women and has served in various capacities within the organization, including as president and as a national board member. Today, Nuzhat will share some background on how this report came to be and also introduce our lead researcher and writer. Off to you, Nuzhat.
Thank you so much, Zainab, and good afternoon. Salams to everyone who's joined us. We're very excited to share this report with you. Our amazing researcher and writer of the report, Asma Jan, has done an a thoroughly amazing job. So before we hear from Asma Jan, I just wanted to give you a little bit of background. Why did we decide that we would undertake this work? Why did we want to do this research? Well, when we started thinking about what was happening in Afghanistan and what has happened since the Taliban takeover, our focus really was on what was happening to the women and girls in that country. And that's still our focus as a women's organization. But what became clear to us is that, equality and justice for women and girls is absolutely paramount. But so is everyday sustenance. So is everyday existence, food, water, shelter, ability to move around, healthcare, clean air. All of those things were in jeopardy because people in Afghanistan after the Taliban takeover were being deprived of basic necessities. They are barely surviving, many of whom are struggling to get by day to day. And of course, what we learned was that, we were involved in doing fundraising, and we were helping people figure out how to send aid to Afghanistan, only to learn that aid was not getting to the Afghan people, that we had a regime in Canada that disallowed for that to occur. So in many conversations with advocates for Afghanistan, and particularly for Afghan women and girls, in the process, we learned about this legislation or the loophole in the Criminal Code of Canada. And it all was, thanks to our anti-terrorism legislation in this country, that we couldn't actually help get the aid to Afghans. This was not aid to the Taliban, it was direct aid to the Afghan people and and of course to the women and girls and their families. So in discussing this issue, we'd had some conversations with Asma Jan and Adina Jan at the AWO, at the Afghan Women's Organization. And then lo and behold, an opportunity arose for us to get some money, to get some research done, to determine whether Canada's answer, or it was an amendment to the Criminal Code, Bill C-41, if that actually had any effect in helping with the delivery of aid to Afghanistan and to the Afghan people. So we decided that we would engage Asma Jan, who happens to be a lawyer and an activist and involved in work with Afghans, Afghan women and children, and many different efforts with refugees and settlement here in Canada. So we thought she was the best person actually to carry out the work, and we were very, very lucky to get a small grant from the Canadian Bar Association's Law for the Future Fund. And so we took on this work, and Asma's been busy. Asma Jan's been busy gathering information, interviewing folks. Many of these individuals work for aid organizations and community members who've been affected by not being able to get the aid to the Afghan people. And she also spoke to folks who were there on the ground in Afghanistan to see what was actually going on and what the effect of not getting the aid there has been on the people of Afghanistan. Um, you know, when we started to think about the project, I had hoped that we would get more insights on Canada's feminist international development policy, but how can that policy possibly work when people are struggling for day-to-day sustenance, for daily living? And so we still challenge the government in using that policy to advance justice and freedom for Afghan women and girls, but they cannot do that if they have no food and water and a roof above their heads. So without further ado, I want to now introduce our speaker for today. And it gives me great pleasure to introduce you to Asma Jan, or Asma Faizi. She's a lawyer and she is the president of the Afghan Women's Organization, Refugee and Immigrant Services Organization. For over 20 years, Asma Jan has been a staunch advocate at the national and international level on issues related to the plight of Afghan women, challenges faced by newcomers to Canada, and human rights issues for refugees worldwide. Asma Jan became a board member of the Afghan Women's Organization, or AWO, in 1998, and has been the president and chair of its board of directors since 2008. The AWO has been providing settlement services for over 30 years to newcomers to Canada, with a special focus on women, their families, refugees, and people who have experienced war and persecution. The AWO has also had several home-based underground schools and educational and capacity building and income generation projects inside Afghanistan and in the refugee camps in Pakistan. The AWO has established an orphanage in 2004 in Kabul. Asma Jan is a lawyer and she currently runs a private practice specializing in refugee and immigration law. She holds a Master of Science in Pharmacology and a Juris Doctor degree from the University of Toronto. In September this year now, 2024, she will begin a Master of International Human Rights Law at Oxford University. Before establishing her own practice, Asmajan practiced in all areas of intellectual property law, with particular focus on litigation, copyright law, and patent law. Over to you, Asmajan. Thank you.
Thank you, Nusrat. Assalamu alaikum. Good morning, good afternoon, and good evening for those joining us from Afghanistan. Thank you for joining us. Before I delve into the findings of the report, I wanted to take a moment to thank a few people. First of all, I want to express my sincere gratitude to the Canadian Council of Muslim Women for always participating and supporting initiatives to bring awareness to the suffering of the Afghan people, particularly Afghan women and children. I want to extend my thanks to the funder of this important research, the Canadian Bar Association's Law for the Future Fund. And I'm also grateful to the members of our advisory committee for their guidance and support throughout the project. I'm just going to name them, but descriptions of who they are and what they do is in the report. Adina Niazi, Corey Levine, Dr. Erica C., Dr. Jawan Sher Rasiq, Martin Fisher, Muhammad Ehsan Zia, Nuzhat Jafri, and Zainab Jamal. And a special thanks to my research assistant, Sophia Paring, whose invaluable assistance has been instrumental in carrying out the research. And I also want to acknowledge other students and reviewers who have contributed significantly to enhancing the quality of this report, including Daniel Bajwa, Grace Lawrence, Nazdana Ayon, Ismail Ibrahim, and Rana Hazarat. So with that, I'm going to share my screen and begin my presentation. So I want to, at a high level, this report examines the legal and operational challenges faced by Canadian humanitarian actors and other Canadian entities that support basic human needs in Afghanistan following the Taliban's takeover in August of 2021. It discusses the complexities that were introduced by Bill C-41, its impact on these entities, and offers recommendations for a more effective framework. The findings of the report are based on information that was gathered through 31 interviews that were conducted between October 2023 and May 2024. And these interviews covered a broad spectrum of perspectives, including aid organizations and other entities of various sizes, large, medium, small, aid organizations, civil society organizations, Afghan diaspora-led organizations, and implementing partners on the ground in Afghanistan. And these interviewees engaged in a spectrum of activities ranging from providing emergency relief, health services, education, promotion of human rights and peace building, and immigration-related services. Members of Parliament and senators that had been involved in the legislative process of Bill C-41 were also interviewed. So to set the context, I want to start by making a couple of comments, brief comments about the current situation in Afghanistan, since Adina Jan will be providing more detail on the current ongoing crisis during her panel discussion. So I want to just emphasize that the situation in Afghanistan today is not just the result of the Taliban takeover in August of 2021, but the results of decades of conflicts going back to the 1970s, widespread human rights violations, climate change-induced natural disasters and diseases, including the COVID-19 pandemic, constant displacements, and enduring corruption, all of which have left Afghanistan in a fragile state. So in order to sustain its population and infrastructure, Afghanistan has been heavily reliant on international aid. And this is why the impact of Bill C-41 is extremely important in the context of Afghanistan, not only because it was the impetus for Bill C-41, but because of the challenges it has created for individuals and entities that want to alleviate the suffering of people in Afghanistan. So when the Taliban took over or took control of Afghanistan in August of 2021, they not only inherited an aid-dependent country, but they also brought with them a unique legal challenge. For the first time, a group subject to international sanctions and counterterrorism financing measures, including individuals that were designated as terrorists, was now governing an entire nation. And so in order to understand this legal challenge, I want to take us all back to 1999. So in 1999, following the bombing of the US embassies in Kenya and Tanzania, the UN Security Council adopted Resolution 1267. This resolution established a sanctions regime primarily targeting individuals and entities that were associated with Osama bin Laden, Al-Qaeda, and the Taliban. And the resolution was passed in the context of increasing international concern over terrorism, particularly as the Taliban, who had at that time control over a large portion of Afghanistan, was believed to be providing safe haven to bin Laden and his network, including Al-Qaeda. And the resolution reinforced the idea that financial resources were central to the operations of terrorist organizations, and that there was a need to prevent these individuals and entities from benefiting from these financial and other material support. And Resolution 1267 also created a committee, a sanctions committee, and it also imposed several key obligations, including asset freezes, travel bans, arms embargoes. And member states were required to enforce the sanctions against any individuals or entities identified by the 1267 committee. And since Resolution 1267 reinforced the idea that financial resources were central to the operations of terrorist organizations, it set the stage for a more comprehensive convention on terrorist financing. So the International Convention for the Suppression of the Financing of Terrorism, which I will abbreviate by calling it the Terrorism Financing Convention, was adopted by the UN General Assembly in December of 1999. And the Terrorism Financing Convention imposed several obligations on member states. And the one that's important for the purposes of our discussion today is the requirement that member states criminalize the act of providing or collecting funds with the intention or knowledge that they will be used to carry out terrorist acts. So to fulfill its international obligations, Canada has implemented counterterrorism measures through both regulatory offenses and criminal offenses. So the sanctions obligations are captured in regulations that Canada has developed over time, targeting various organizations and entities and individuals, including the Taliban. And the criminalization or the criminalization obligations are found in Canada's criminal code. So this takes us to 2001 and the September 11 attacks in the US, which had been orchestrated by the Al-Qaeda network, prompted the US to push for stronger international measures to combat terrorism. And so the UN Security Council responded by adopting Resolution 1373. And this is a key resolution that was passed very quickly. So it was passed on September 28th, so just 17 days after the attacks of September 11. And while the previous Resolution 1267 addressed only specific groups like the Al-Qaeda and the Taliban, because there was no broad framework for obligating member states to combat terrorism comprehensively, this resolution filled that gap by establishing a regime that applied to all forms of terrorism, regardless of the perpetrators. And Resolution 1373, again, called on member states to do a whole host of things. And the one that's important for our purposes, again, is that it included the requirement for criminalizing the financing of terrorism. And as a member state, Canada had an obligation to comply with this resolution. And although Canada had long been involved in international efforts to combat terrorism and was an early signatory to the Terrorism Financing Convention, it still lacked a comprehensive domestic legal framework to fully meet its obligations under these agreements. And so on October 15, 2001, about a month after September 11, Canada introduced the Anti-Terrorism Act as Bill C-36, and this was passed approximately 2 months later on December 18, 2001. This legislation introduced sweeping reforms to Canada's legal and security framework. Again, but for the purposes of today, in order to comply with Resolution 1373 and the Terrorism Financing Convention, the Anti-Terrorism Act introduced terrorism financing provisions in Canada's criminal code to make it a crime to knowingly provide, collect, or use funds to support terrorist activities or terrorist organizations. Because this law was being passed or ushered through the legislative process very quickly, some members of parliament and senators expressed concern about the application of this new law to the ability of charities to conduct their operations. There were discussions that the Anti-Terrorism Act was not intended to unduly impact charities engaged in legitimate charitable work. And the report highlights some of these discussions, but I just wanted to quote the Senator Sharon Carstairs, who was the leader of the government at the time, who said that the language of Bill C-36 has been carefully drafted precisely to ensure that no one could be convicted who innocently facilitates a terrorist activity. And she went on to say that the innocent are fully protected under this bill. And this and other statements that are in my report by parliamentarians are referenced to show that the intention or the understanding at the time when this law was passed was that it was designed to protect innocent parties, but it was really meant to be there to prosecute those who knowingly were involved in terrorist networks and supporting these organizations. And so fast forward to 2012, and a key decision from the Supreme Court of Canada came down. The decision is called R.V. Khwaja. And this decision, the court considered some of these terrorism financing provisions that were had been introduced by the Anti-Terrorism Act. And the court held that these provisions in the criminal code should be interpreted in light of the legislative purpose. And the Supreme Court's understanding was that the purpose of the legislation was to provide a means by which terrorism may be prosecuted and prevented, and that it was not that the intent behind these provisions were not to punish individuals for innocent, socially useful, or casual acts which, absent any intent, indirectly contribute to terrorist activity. So again, this interpretation of our Supreme Court, which is the highest court in Canada and whose decisions are binding on our lower courts, reinforced the understanding that the parliamentarians had when they passed this legislation and these provisions, that they were not meant to criminalize legitimate humanitarian or charitable types of activities. And so just to quickly summarize in that, so prior to the Taliban taking over, the situation and the law of the land, if you will, was that the Taliban had been around since the 1990s, that there were sanctions that applied to the Taliban, that while there were criminal code provisions that related to countering the financing of terrorism, they were understood not to apply to innocent acts, which, absent any intent, indirectly contributed to terrorist activities. And so then we come to 2021 and the Taliban's takeover of the entire region of Afghanistan. And like I said before, that this created a unique legal challenge, because for the first time, a group subject to international sanctions and counterterrorism measures, including individuals designated as terrorists, was now governing an entire country. And so the international sanctions and these measures that were designed to prevent financial and material support from reaching the Taliban were suddenly being applied to, again, a governing body. So, for example, routine payments like taxes, fees, or even incidental costs to the Taliban regime could potentially be interpreted as providing material support to a terrorist group. And so this interpretation potentially exposed humanitarian actors and other entities to severe criminal and civil liability penalties. For example, organizations faced the risk of being fined, losing their funding, losing their charitable status, or even facing criminal prosecution for doing what they had always been doing, which was to deliver aid to those in need. And so to navigate this landscape, humanitarian actors and other entities that were providing aid in Afghanistan urgently sought guidance from national and international bodies. And the responses varied. So if we start with the response of the international community. So the US leveraged its long-standing flexible licensing system to allow the aid to flow back into Afghanistan. So what it did was it issued licenses, general licenses that allowed individuals and entities to continue to deliver aid in Afghanistan. And the entities or the activities that were covered by these licenses were very broad, including things ranging from provision of food, medicine, to supporting basic human needs such as livelihood support, health, and settlement assistance. And these licenses were issued very quickly, so in September of 2021 and also December of 2021. The United Nations adopted Resolution 2615 in December of 2021. And this exemption covered, again, humanitarian assistance and also other activities that support basic human needs. The UK, Australia, New Zealand, all of these other nations created exemptions in their own domestic legislation and to help facilitate the delivery of aid by their organizations that were from UK, Australia, and New Zealand. And the licenses that were issued by the US and the exemptions that were put in place by these other countries were all self-executing. And what I mean by self-executing is that these licenses and exemptions automatically took effect without the need for aid organizations within these countries needing to take any additional action or seeking permission from the government or going through some kind of a process. It automatically applied. And so what we see that by the beginning around February, for the beginning in the first winter of when the Taliban took over Afghanistan, all of our major allies and the UN had put into effect these broad exemptions that allowed for the delivery of aid into Afghanistan. And then now I just want to shift focus to Canada. And although Canadian organizations were also facing similar uncertainties as their international counterparts, unfortunately, our government was slower to respond than our allies. And certain organizations that were interviewed expressed that they had approached our government as early as 2021, seeking clarification about Canada's sanctions seeking clarification about how Canada's sanctions against the Taliban would impact their work, since the Taliban were controlling all of Afghanistan. And they also asked whether Canada was going to implement an exemption to meet its international obligations under Resolution 2615. And to follow what our allies were doing. However, through ongoing discussions with the government, it became apparent to these organizations that our government was not focused on Canada's sanctions regime, but more concerned with the terrorism financing provisions in Canada's criminal code, and was interpreting these provisions broadly to include incidental payments made by aid organizations that were operating in Afghanistan. They were essentially taking the position that if aid organizations working in Afghanistan had to pay taxes or rent or buy food or supplies, that these activities would be caught under the terrorism financing provisions in Canada's criminal code, and that these organizations would be opening themselves up to potential criminal liability. So the government felt that they needed to amend Canada's criminal code to address this perceived problem so that there would be clarity for everyone. And just in May of 2022, I just want to highlight that there was a group of experts in international law, criminal law, administrative and public and constitutional law that provided a legal opinion to the government. And essentially, they felt that the Canadian government's legal interpretation was inconsistent with both the legislative intent of the provisions of the criminal code and also contrary to the Supreme Court of Canada's interpretation in the RV Khwaja case. So they were urging that there was no need to amend the criminal code because these provisions of the terrorism financing provisions of the criminal code did not apply to the activities of these aid organizations. And all of this was happening in the context of various committees that were struck or initiated by the House of Commons and the Senate. And reports were coming from these committees where there were urgent calls for action for the government to address this barrier to aid delivery. And in those reports, there were recommendations to introduce an exemption. And there's more detail in the report about these committees and their and what they were asking for. So the government finally, in March of 2023, introduced Bill C-41. So Bill C-41, what it did was it amended certain provisions in the Canada's criminal code by creating a regime that would allow the Minister of Public Safety to grant authorizations to eligible individuals or organizations to carry out their activities in regions that are controlled by terrorist groups. So essentially, anybody who wanted to do humanitarian work inside Afghanistan and wanted to ensure that they were not going to be criminally prosecuted would have to go through this authorization regime and seek permission from the government to do their work. And so this initial version of the bill sparked widespread concern among humanitarian actors and other entities because it didn't provide that broad self-executing exemption that the sector was looking for and that had already been implemented in other jurisdictions. And this proposed authorization regimes appear to be very complex, intrusive, and cumbersome based on the language that was drafted, that was in the bill. And so rather than providing the clarity that was being sought, it provoked alarm due to its unprecedented nature and potential breaches of both international law and principles guiding aid organizations. And a lot of these aid organizations came out strong against what was happening. So after significant advocacy from the sector for a broad self-executing exemption, again, similar to what our allies had, the House of Commons Standing Committee on Justice and Human Rights amended Bill C-41. But the amendment didn't create that broad exemption that the sector was looking for. What it created was a bifurcated system. And there was a self-executing component for humanitarian assistance activities, which was not defined in the Act. So it wasn't clear what types of activities were covered. And for other types of activities that support basic human needs, like education, livelihood programs that protect and promote human rights, you would still need to go through the authorization regime. And the additional issue at the time was that even though you were required to go through the authorization regime, there was no regime in place. That still needed to be, the government still needed to work on creating that regime. And so even though that self-executing part exemption provided some flexibility for organizations to continue their work inside Afghanistan, there was this additional barrier for all these other types of activities that Canadian organizations wanted to initiate or continue inside Afghanistan. And the interviews highlighted that there were significant challenges both with the exemption itself and also the authorization regime. One of the biggest concerns, as I mentioned before, was the definition of what is a humanitarian, what is included in the definition of humanitarian assistance. And this ambiguity created required guidance. There was a lot of requests for guidance from the government, and that guidance didn't come until June of this year. So it took another year before the government came out with its guidance on what it understood, a non-binding guidance on what the government felt what might be included, but encouraged organizations to seek legal advice about, whether or not whatever you're doing falls under that definition. And so that confusion, that period between when there was no definition and there was no guidance, some organizations halted critical activities that they were conducting inside Afghanistan, such as vaccination programs, because it wasn't clear whether it fell under the exemption or whether they needed to seek authorization, and there was no process for them to seek authorization. So organizations, at least one organization, halted their activities on relating to that. And when the guidance came out, as I said in my report, there's a section that describes some of the confusion that has come out from the guidance that has been released by the government on what constitutes that humanitarian assistance. There was also confusion on the scope of the actors that are covered under these two different streams of activities. So, for example, there's confusion around who is so in order to qualify to carry out activities under the exemptions, you need to be a, quote, impartial humanitarian organization. And so there's some confusion around, well, who falls under that definition. The guidance that has been provided has directed people to look at certain international instruments to help understand what that includes, and to seek, again, legal advice on who might be included in there. But just so people understand sort of the confusion and how this regime has created some barriers, is that you, as an individual, are not covered under the exemption. So I, as a Muslim who wants to provide charity, or if I want to send some money inside Afghanistan, or during Eid, I want to send money to my family so that they can sacrifice a sheep and distribute to the poor, that type of activity I will not be exempt, and I actually need to go through the authorization, seek permission, go to the government and say, I want to do this, will you allow me to do this? And or I would need to give whatever money that I've collected, I would need to find an impartial humanitarian organization that would be able to deliver that money for me inside Afghanistan. And the other barrier so if there's a loose group of association of people, so let's say there's a flood in a village back home, and you and a few people from your community wanted to pool your money together and send it to help that region or that village, again, you would be not able to do it under the definition of the impartial humanitarian organization, because under international law that there's a definition, and they say those loose associations are excluded. And so then you would be left again to look for an organization that fits that definition, give your money to them, and hope that that money is going to get to that village that you want that money to go to. So you are not able to do that. And the additional difficulty for these loose association of individuals is that you can't even go through the authorization regime, because as a loose association, you are excluded from the eligibility criteria of who can actually put in an authorization. So that small group of people, we would actually need to become more structured, and that's not defined in the Act. And then we would be able to carry out, and then we would be able to put in a request for authorization to do that work. So it has really created a barrier for both individuals to be able to help in their communities back home, and also for groups of community or groups of people coming together wanting to help. But the biggest issue, as I said, was the delay in the implementation of the authorization process, which was officially launched in June of 2024. So that's almost a year after the passage of Bill C-41. And I received some information today from an inquiry that was made to the government about the status of the authorization regime and how many people have applied. And the Global Affairs Canada reported back to say that as of August 22, 2024, the government of Canada has submitted 7 authorization applications for its own work in Afghanistan. So there's 7 applications from the government of Canada. There's 1 application that has been received from outside government, and no authorizations have been issued and no authorizations have been rejected. So that's concerning because even these applications from our own government have not been authorized. So it raises the question of how long is this process actually going to take, both for our government, who you would imagine would be able to get these authorizations quickly, but also by these other non-governmental organizations, a lot of whom are small organizations that may not have the capacity to meet the requirements that are set out in the authorization regime. So the reason I'm raising these issues is that to illustrate the next part of the findings of the report, which is really the challenges and the consequences that have resulted from this lack of clarity and the delay in the process. And the report highlights 4 areas where the implementation of this bill has had an impact, including programmatic effects, operational challenges, third-party implications, and consequences for beneficiaries. I'm only going to highlight a few examples just so you get a sense of the types of challenges that organizations have faced. But I would highly recommend that you read the report and really to get the full appreciation of the impact that this has had on people trying to do good in the world. So Canada's, again, this cautious approach that Canada has taken, and while it's well-intentioned, it placed Canadian aid organizations in a very difficult situation. They had to make a decision between taking a risk and continuing to do what they were doing, or to stop what they were doing. And so there was a spectrum of responses from organizations. Some organizations, and they have been public about this, such as Doctors Without Borders and Islamic Relief, continue to do their work inside Afghanistan. They felt they were covered under international humanitarian law and under Canada's laws. But other organizations were understandably more cautious in terms of not wanting to be criminally liable, suspended their programs, and because they were waiting for the government to give them the clarity that they needed. Now, some other organizations started to adjust their programs to avoid triggering the laws. And so examples of some organizations, so they just stopped doing work that would fit the categories of the basic human needs. So they stopped providing programs relating to education, human rights, livelihood programs. They just shut all of that down, and they shifted to providing emergency relief so that they could meet the criteria. Other organizations continued to do their work inside Afghanistan, but they severely changed their operations and their procurement processes. And this one interview will stay with me and has stayed with me because of what was, what they told me was that they were being told by the government that not a penny could go to the Taliban government. And so because they were being told this organization sourced all of their materials and even their water and their food from Pakistan. And then they would come in the trucks and they would make their foods in the trucks so that they wouldn't trigger Canada's anti-terrorism laws. And so they were, because they were told that not a penny could go, and so they couldn't even buy a bottle of water or a sandwich to be able to carry out the life-saving work that they were trying to do inside Afghanistan. So this is the extremes to which some of these organizations went through. And I commend these organizations for the commitment they had to the people of Afghanistan to want to actually do this kind of restructuring to be able to save the lives of Afghans in Afghanistan. A few other organizations just halted their programs in Afghanistan altogether, and they just started to serve the needs of Afghans in Pakistan and other regions of the world, like Turkey. And one organization actually even considered completely restructuring their program to fall under the jurisdiction of their international partner, but ultimately decided that that was too complicated, and they didn't do that. Some of the operational challenges were the stress of navigating these complexities took a toll on the staff, on the frontline staff who saw this need, but they weren't able to assist. They just didn't understand, well, why can't we do that? Why are other countries able to do this? What's wrong? Why can't we help these people? And there were also financial and operational costs associated, again, with not only moving their projects and restructuring, but also with stopping their projects. And then once the exemption came into effect, even for those organizations that wanted to make use of the exemption, they had to restart their programs. And it took them, I think one organization mentioned it took them between 3 to 6 months to restart that program that they initially had in place once the bill came into effect. And this, focusing on the bill, interpreting the law, does it apply? What activity applies? What doesn't apply? Finding lawyers, all of these took away and diverted these organizations from their core work, and at a time when there was such a dire need inside Afghanistan. I'll just mention one third-party implication, which is the bank de-risking, because this was an issue that pretty much all of the organizations identified. And this created challenges because despite the passage of Bill C-41, one of the interviews said that the banks were reluctant to assist with fund transfers due to the lack of a clear government statement affirming that the law permitted these kinds of transfers. So they were being risk averse. And this reluctance forced organizations to resort to unsafe measures of carrying cash, borrowing money, or relying on other partners or other organizations to cover the costs. And one of the interviews working on the ground mentioned that even with the UN exemption, banks were reluctant again to transfer money. And even when they were writing on the checks, humanitarian assistance only, the money often didn't reach Afghanistan. And so they described that they had to, these aid workers and these partners on the ground had to sleep in the offices because they didn't have access to money to pay for fuel to go home. And the consequences to the beneficiaries, which is the Afghan people, was very profound. There's a section in my report that around the missed opportunities that I encourage everyone to read. It provides some data that was gathered from various Canadian organizations on the missed opportunities resulting from these laws or these barriers that were created. And the analysis is based on data that was collected in July 2022, and focused and the data is from 12 organizations. It's not comprehensive, but it just gives you a snapshot of what was happening. And it was an estimated 5.8 million Canadian dollars worth of projects were closed or indefinitely suspended. And then additionally, approximately $84.5 million worth of ongoing projects were encountered various challenges. And the impacted projects covered several critical areas. And these areas aligned with Canada's international development priorities and Canada's feminist international assistance policy. And most of these focused on food security, nutrition, health, education, child protection, water sanitation and hygiene, vocational training and livelihoods, response to natural disasters. And there are examples of the specific types of programs are in the report, and I would encourage you to read that. And several interviewees shared that they also chose not to pursue special appeals for Afghanistan because of the lack of the clarity around Canada's laws. Again, these are just examples of a lot of the missed opportunities to support the Afghan people, because if you remember that the situation in Afghanistan unfolded before the crises in Ukraine, in Gaza, and Sudan. And so there was a lot of interest and a desire to help make that change, and we will never get that back now. And a number of the Afghan women-led diaspora organizations were also not able to continue or initiate their programs in Afghanistan. And some of these women had been actively involved in carrying out these projects in Afghanistan. They were brought here by the Canadian government. They registered their organizations, but they were not able to carry on their projects inside Afghanistan. They feared losing momentum and on the progress that they had achieved over the past 20 years. So they were prohibitive, and they were essentially turning away many opportunities that came their way for doing projects inside Afghanistan. Just a quick trend was that many of the examples of the programs that were shut down or the opportunities that were turned away related to supporting Afghan women and children. And don't have time to go over the impact to look at how Bill C-41 aligns with Canada's feminist international assistance policy, but there is a section in my report that covers that, and I would welcome you to please read that analysis in the report. So where do we go from here? And I want to end by kind of talking about the significant concerns that were expressed by the interviewees on the practical impacts of Bill C-41. And we want to suggest that this current bifurcated framework may not be sufficiently responsive to the urgent needs on the ground, and it's potentially undermining Canada's broader international assistance goals. And so we want to urge the Canadian government to genuinely reassess its approach in Bill C-41 to ensure that the framework that it has created does not inadvertently criminalize or hinder the essential work of these humanitarian actors and other entities that support basic human needs. One of the things that was in the legislation was that there was going to be a review after a year to see how things are working, because this legislation was passed relatively quickly from the time that it was proposed to the time that it was passed, but not, it was only a few months, and there was a very short opportunity to pass it. There was this provision that was put in place where the government essentially said that we want to look at this and make sure that it's workable and it's working. And I would really encourage our government to really genuinely look at this framework and to assess whether it's actually meeting the intended purpose, which was to enable aid delivery in Afghanistan and other regions in the world. And so the key recommendation that I have, and there are many others that I'm not going to go through, but only the key one, is to broaden the exemption to include these other types of activities that support basic human needs, like education and livelihood programs and programs that promote human rights and those types of programs. And second, to do away with the authorization regime. To repeal the authorization regime because it's unique internationally, and just to follow what our allies have done and to follow the guidance from the United Nations Security Council 2615. So the sort of second last point I want to make is that although the report focuses on the implementation of this bill in the context of the crisis or in context of Afghanistan, it's important that this bill does not only apply to Afghanistan, it applies to all regions around the world that are being controlled by designated terrorist entities. And so this bifurcated system, while having profound impact in Afghanistan because it's the entirety of the country, is also going to have impact in other regions of the world, most likely and predominantly in the Middle East countries. I see that this will unfold also in issues might unfold in Gaza, in Yemen, in other regions of in Africa, so that it has broader implications. And so I really hope that the government will look at this carefully and see whether or not it's actually meeting its intended purpose. And just with the third anniversary of the Taliban takeover now passed, I also want to urge Canada to urgently increase its humanitarian assistance in Afghanistan, because one of the things that came out in this research, and there's data in the report that I will not be able to go through now, but it shows there's data from Global Affairs Canada and the Canadian Partnership for Women and Children's Health shows that there's a trend in decline in projects directed in Afghanistan by Canada, and a trend of decreased international assistance expenditures to Afghanistan. So it's really important at a time when the people of Afghanistan are facing significant challenges to ensure that we don't let these types of laws, not allow for to alleviate the suffering of the people. And I will just quote one of the people that provided, one of the people on the ground said during one of the responses to the survey was that we felt that why we are living in a situation that even humanitarian aid donors do not support us. What is the fault of innocent and poor people that are suffering due to sanctions against Afghanistan? And so I'd really urge us to relook at how we deal when we're dealing with these kinds of situations. What are the frames by which we are drafting our laws, and what are the frames by which we are monitoring and assessing and hopefully reflecting and changing to ensure that it is being responsive. Last, I want to end by acknowledging and commending the tireless work and advocacy of humanitarian actors and other entities that support basic human needs, who have risked much to support vulnerable populations, not only in Afghanistan, but also around the world. And their dedication to upholding the dignity and humanity of those in need, even amidst challenging conditions, is both admirable and vital. And I hope that our government will listen to their challenges and amend Bill C-41 to enable them to continue to do the great work that they do. So I'll pass it on back to Zainab and stop sharing.
Thank you, Asma, so much for sharing your work with us, and for so clearly highlighting the challenges we Canadians face when delivering aid to Afghanistan. And I'm sure there are many questions and comments. Please note them and we'll address them during the Q&A session at the end. We will now hear from our two respondents who will offer their insights and reflections. Our first respondent is Adina Niazi. Adina is a former lecturer at Kabul University and the founder and executive director of the Canadian Women's Foundation organization. Under her leadership, AWO has been a vital force in supporting and advocating for refugees and newcomers in Canada. The organization has successfully sponsored and settled over 3,000 refugees. Adina also founded the National Coalition in support of Afghan women and brings over 26 years of experience in managing refugee resettlement and settlement services. She has served on the boards of several refugee-serving organizations and is the recipient of numerous awards for her dedication and achievements. Adina John, we look forward to hearing your thoughts.
Thank you very much, Zainab Jan. Good afternoon, everybody. Salam to all. I want to start by expressing my heartfelt thanks to CCMW for their exceptional leadership in administrating this research. Your commitment in advancing our understanding of these crucial issues is deeply appreciated. Additionally, I want to congratulate Asma Faizi for her outstanding work in carrying out evidence-based research with a very remarkable professionalism and also efficiency in a very short, notable short time. I'm honored to be part of the panel alongside the two incredible women, Erika, C, and Asma. Asma has eloquently addressed the legal issue aspect of Bill C-41, and I'm looking forward to hear also from Erika. I could strongly support the recommendation that Asma has put forward. However, It is crucial to also consider the human elements of the real world impact on the population and on the world. I want also to express that my heart aches for suffering of each human worldwide. However, given my close connection with the Afghan and the years of experience working with the Afghans both inside Afghanistan and also in Canada, my today's focus will be on Afghanistan. Afghanistan has been devastated by decades of war, which was imposed on this peace-loving nation, also by human rights violation, corrupt government, systemic corruption, and impunity that caused instability, economic hardship, and food insecurity in Afghanistan. These circumstances pushed the country to heavily depend on international aids. The withdrawal of the Soviet and its allies and Taliban's takeover, which was compounded by natural disaster, including flood, landslides, earthquakes, and effects of climate change, has plunged the country into the unprecedented crisis and worsened the already fragile state to the brink of collapse. According to the United Nations, Afghanistan is facing one of the worst unbelievable humanitarian disasters. Millions of women and children are suffering. They are facing the harshest reality of conflict, poverty, and lack of aid. On the top of these crises, the Taliban has imposed harshest restriction, particularly on women, barring them from working most of the job, and closing the schools, higher education for the girls. The stress of these restrictions is also leading to more cases of domestic violence, mental health problems, and feeling of helplessness amongst Afghan people. U.S. institution of peace indicates that millions of Afghans face acute malnutrition and starvation in the coming months. And according to the International Rescue Committee, the IRC, starvation will kill more Afghans than in the past 20 years of war. Nearly 3.2 million children and 840 pregnant and nursing mothers suffer from acute malnutrition. United Nations Office for the Coordination of Humanitarian Affairs, OCHA, reports that nearly 29 million people out of the 40 million Afghan population need urgent humanitarian assistance in 2024. According to the World Bank, over 90% of Afghan population live under poverty line. Bill C-41 was introduced with the aim of preventing any support from reaching to those who threaten peace and security. This goal, of course, is one of that we all support. However, in reality, the requirement to seek authorization imposed by this legislation has also tragically impacted the innocent, vulnerable, and those who they call already victims. Without these restrictions, organizations were able to assist more freely. In such situation of receiving the assistance, the lives of many Afghans will be transferred. For instance, as Nus had just finished, in 1990s, when Taliban were in power in Afghanistan, we were able to, our organization was able to run income generating projects inside Afghanistan, and also we had educational programs there. At that time, we were able to save many lives, and also gap to some extent, also felt some of the gap to some extent in the education. Leveraging from these past experience, we could also establish similar programs and save some children at least from starvation. And also, it was also possible to open the schools inside Afghanistan. I repeat that IRC has noted that more Afghans are expected to die from the starvation than in the past 20 years of war. By requiring organizations to seek authorization and restricting the ability of organizations to deliver aid for certain activities, we are unintentionally contributing to the suffering of the people. We have often felt, especially I really feel, that in our effort to punish those who deserve it, we punish the innocents alongside them. Let's remember that the enemies are not children suffering from malnutrition and the women struggling to keep their families safe. They are the victims of ongoing tragedy. Our policy should reflect our compassion and our commitment to humanitarian principles. Let us also ensure that our action aligns with our values. The lives of countless Afghans depend on our ability to respond to the crisis with charity, compassion, and urgency. Let us work together to ensure that our humanitarian efforts are guided by those principles. we must come together to ensure that Afghan and girls are not punished twice. Thank you, and I'll pass it back to Zainab in the interest of the time.
Thank you, Adina John, for your powerful reflections and sharing your experiences of working in this space for 20 plus years. Next, I would like to introduce our second respondent, Erica C., Senior Legal Counsel and Senior Director at the Canadian Red Cross Society. Erica has worked for the Canadian Red Cross for over a decade, first as an in-house legal counsel, and more recently as the founding director of the CRC's New Humanitarian Services Research Center. Prior to immigrating to Canada, Erica worked as an elder rights lawyer in the United States and on issues related to women's inheritance rights in Kenya. Erica holds a JD from the University of Wisconsin-Madison and an LLM and a doctorate of law from the University of Ottawa, where her research focused on assessment of credibility in gender-related refugee claims. Erica, we look forward to hearing from you.
Thank you so much, and hello, everyone. First, let me add my sincere thanks for allowing me to be part of this panel today and offer some context and comments on the report. It's a great honor, and it's a really strong report, and I hope everybody joining the call today has a chance to review it in more detail. We are, I think, running a little short on time, so I'll try to keep my comments brief. However, I did want to start by just putting the idea of the report in the greater context of laws in Canada, because I think it helps add weight to what we read in the report about challenges on the effectiveness of the implementation of the authorization regime. So as Asma had outlined, Bill C-41 modified a section of the terrorism-related offenses, specifically 8303 sub 4, to allow for both a humanitarian exemption and then an authorization regime to allow action. So in other words, it was an authorization regime to something that would otherwise could be interpreted as a serious crime. So that's within the criminal code, but actually within Canada, anti-terrorism related provisions actually sit in two other types of laws too that I think are worth mentioning here today, because it helps us interpret Canada's approach to this law and also to this ultimate goal of preventing terrorism while also not hindering needed aid to terrorism impacted geographies. So the other two regulatory frameworks that I want to mention today, in addition to the criminal code, are sanctions regulations under the United Nations Act and also the Special Economic Measures Act, and then also a host of laws that control finance, and in particular, movement of money across lines, and also on organizations, Canadian organizations. So, for example, of course, charities like my own are heavily regulated through the Charities Directorate, as well as other laws that, again, monitor and control flow of money. The sanctions regime also is a main way that Canada implements sanctions measures through the UN as well as autonomous sanctions. So each of those three together inform Canada's approach towards this law. And the reason I want to mention that is, as Asma had been outlining and as is detailed in the report, Canada's approach to this issue has differed from other member states of the United Nations who have put in humanitarian carve-outs that protect the provision of humanitarian aid in these unique contexts, as well as that crucial piece of other activities to support basic human needs. That piece isn't currently reflected in the criminal code revisions. So I think that is the good news story is that Canada has some best practices in the international community to inform what the approach should be. And I think it is useful to keep in mind too that the humanitarian exemption that we do see in the law is a result of a lot of efforts, both within the sector, including the Aid for Afghanistan campaign that my organization and many others participated in, and actors within the government who were aware of the extreme levels of need in Afghanistan and other geographies as well, and wish to progress the law to provide clarity. As Asma has outlined, there's still some ways to go to help ameliorate and lessen the vagueness that is still present in the law and the confusion that organizations are feeling to know whether their planned activities will violate the law. And I think the other broad thing I would say that, as people living in Canada, we want clarity on what constitutes a crime and what doesn't constitute a crime. It's one of those areas of law that you should be able to read and know what you're doing, how that might fit in, without having to read a lot of other things. So we should always, as people living in Canada, understand the basic circumstances of what constitutes a crime. And again, I think in this context, it's in conversation with sanctions regimes and other legal mechanisms that are very well established to control the flow of money. In the interest of time, I think I will pause there for today, but again, I commend Asma for an excellent in-depth report that does highlight the experiences of organizations and has a lot of great insights. Thank you.
Thank you so much, Erica, for your insights and for lending us your expertise on this matter. We'll now open up the floor to questions from the audience. Please feel free to submit your questions through the chat or the Q&A box. We don't have much time left, but we'll do our best to address as many as possible. So I see some questions in the Q&A box. So we have a question from Fazia. Thank you for an informative presentation. The same authorization requirements apply to other countries? Is there a time period in which a response to a request must be processed?
So those are great questions. So yes, so it does apply. It would apply to any region in the world that is controlled by a designated terrorist entity. And there's lists of who is a designated terrorist entity on the Ministry of Public Safety, I believe. I don't know if it's on their side or the Global Affairs Canada. So one of their websites have a list of who is, which regions might be covered. And if you have a question about if you're working in a particular region, you're not sure, there's a mechanism where you can ask the government whether this law applies. And in terms of a time period, and I'm assuming this is the time period by which a response from the government to the authorization regime. No, there is no such response period. And there were lots of questions when this bill was being passed around how long might that authorization process take? And there was no, because the process hadn't been put in place, the government was not able to answer that question. And the purpose of this one-year review is to hopefully shed some light on that. But as far as we know, the regime was launched on June 19th. And as I mentioned, that of the data that I received regarding the number of authorizations they've received since then, none of them have been granted. So if the authorizations began in June or July, so that it's still a few months, and so it looks like it might take a few months before. And again, there's probably a process in place, and so potentially could become faster at a later time, but right now there's no clarity around that.
Thank you, Asma. We have a question about women's issues. So the question is, will you be discussing what is happening to women and girls in Afghanistan? What advocacy is possible?
So I think Adina, John provided some information about sort of the condition of women in Afghanistan. And unfortunately, this is not, we don't have time to be able to go through what's happening there. There are various mechanisms that are being floated or discussed internationally that indicate that we need to not only hold the Taliban accountable for what's going on inside Afghanistan, but we need to hold the international community accountable for what is going on inside Afghanistan. And I think I would say as an Afghan that we also ourselves need to hold us Afghans accountable to ensure that we are able to bring that change inside Afghanistan. And unfortunately, it's not the forum here to talk about those issues because they are complex and there's probably lots of people with different opinions. So we hopefully we will have could have another webinar on that issue at another time.
Thank you, Asma. Another question is there a likely timeline for introductions of amendments to Bill C-41?
Maybe I can respond, and then Erica, if you wanted to add anything there. First of all, is the timeline would come into place if there's a desire to make the change. So first we need to assess and see whether our government is going to take, you know, the evidence or the examples that have come out, at least from this report, and for further discussions with aid organizations and the stakeholders to find out how this law is really impacting them, to hear what the issues are, and to, you know, meaningfully consider those issues and bring a change about. Whether or not that will happen is tricky, particularly also because we're in the there might be an election soon. So Erica, if you wanted to add something.
Yeah, it is a good question and definitely an unknown. And without you know, without weighing in directly on the recommendation of whether revision or is needed, I think that really one of the key things that this report gives is a block of information from the community about how this law is working out in real life. So there are other pieces that Asma had mentioned, I believe about a one-year review, for example. And I think that what this report adds is crucial, and frankly, I think should happen all the time, where she was able to go to impacted organizations and ask them whether, with the information available, did they have the clarity they needed to proceed or not. And she was able to then gather those thoughts together and bring them into this report. And that piece of information, that insight from the field is unparalleled. It's so valuable. And it is my hope that the government will look at that and consider what that report is saying, which is that that this vagueness and de-risking is hindering the goal, which is to get aid to where it's needed most. So I'm not sure how to answer the revision question specifically, but again, I really believe and want to emphasize how important the information that this report brings is to evaluated processes within the government.
Thank you, Erica. Another question from the Q&A box is that, what is your primary goal with this report? Is it for the Canadian government to amend Bill C-41? If so, would the author of the report and its advisory committee be willing to speak with the Canadian government in stakeholder discussions on how to best amend Bill C-41?
So I think Erica just beautifully answered that question, and that was really the purpose of this, was when I embarked on this research, I really wanted to know, well, how are things going to pan out? Are people going to be able to, is this going to ease their ability to be able to deliver aid? And if it's not, what are the challenges that they're seeing, so that we could, so we could bring it back to the government and say, look, this is how it's, things are happening. And the intention was never to come out and identify all these challenges and to show that, there's all the sort of flaws with the law, but the intention was just to gather information and to understand the process that these organizations went through to get the law and what it's going to take for them to be able to implement it. And so the recommendation is to amend it. And I would, there are a few other people on the committee or the advisory committee that I think have been actively involved in engaging with the government, and I would imagine that they'd be willing to go back and engage in discussions with the government if that's what the government wants from us.
Thank you, Asma. We have some questions in the chat box as well. So this question is, I have asked the Ministry of Public Safety for information on application for authorization in January and followed up a couple of times. So far, I have not received any info. Where can we get access to the application form?
So the authorization regime and the application is on the website of the Ministry of Public Safety. And while Adina, I think, answers the next question, I'll see if I can find the link and put it in the chat.
Thank you, Asma. Yes, so this question is for Adina. Any update on the progress of the resettlement of Afghans in Canada over the last 2 years?
Okay, thank you for the question. It's asked by more the Afghans with the families overseas. Yeah, actually, the special measure for resettlement of Afghans has been over in the December 2023. So now the Afghans are coming under the regular resettlement program, which is a little bit complex and it depends on different visa posts. So what's happening right now, there are two ways, like whether they come under government sponsorship program or under the SAW sponsorship agreement holders, which it means each sponsorship holder gets limited quotas or resources, and under that they are bringing funds from different countries. And if you're talking about the timeline, it depends on the visa post. Some visa posts take shorter and some takes longer. So there's not very clarity on how much time, and cannot give a certain response of how long it will take. It depends on the different cases, case by case.
Thank you, Adina John. I don't see any more questions, and in the interest of time, we'll conclude our Q&A session. And I want to take a few minutes to thank some key people. So thank you to Asma for writing this report with the care and nuance that this topic deserves. Your research highlights the real and urgent impact of Bill C-41 on aid delivery in Afghanistan, particularly on women and girls. Thank you as well to Adina Niazi and Erica C. for your thoughtful reflections, and to Nuzhat for your leadership throughout this process. I would also like to thank our advisory committee members, research assistants, and CCMW staff who contributed to this project. To everyone who attended today, thank you for joining us and for your engagement with these issues. The full report is now available on our website, ccmw.com. Please share it widely with your organizations, government officials, and anyone who may find this beneficial and help us address this. And if you have any questions or comments about the report or anything discussed today, feel free to reach out. We would love to hear from you and discuss possible collaborations. Our email is info@ccmw.com. I'm also putting my personal email for anyone interested. And finally, I would like to take a moment to stress the need to hear and amplify Afghan voices, particularly those of the 30+ million people still living inside the country. This is a young and growing population, with thousands being forced to return from Pakistan and Iran every day. These individuals deserve to live with dignity and opportunity, and they should not be punished for the actions of a few. Again, thank you once again, and we look forward to staying connected as we continue this important work. Assalamu alaikum.